Article 1831. On application by or for a partner, the court shall decree a dissolution whenever. Number 1. A partner has been declared insane in any judicial proceeding or is shown to be of ulit nga visit. Ulitin ko. Article 1831. On application by or for a partner, the court shall decree a dissolution whenever. Number 1. A partner has been declared insane in any judicial proceeding or is shown to be of an unsound mind. Number 2. A partner becomes in other way incapable of performing his part of the partnership contract. Number 3. A partner has been guilty of such conduct as tends to affect prejudicially the carrying of the business. Number 4, a partner willfully or persistently commits breach of the partnership agreement or otherwise so conducts himself matters relating to the partnership. To the partnership business that is not reasonably practicable to carry on the business on partnership with him. Number 5, the business of the partnership can only be carried on at a loss. And number 6, other circumstances render a dissolution equitable. Next. Under Article 1813 or 1814, number 1, after the termination of the specific term or particular undertaking. Number 2, at any time in the partnership was a partnership at will when the interest was assigned or when the charging order was issued. Grounds for dissolution by decree of court. There are many situations or events that may constitute a valid reason for dissolving a partnership, but which are subject to dispute or difference of opinion to make a judicial dissolution necessary. Dissolution of a partnership may be ordered judicially after a hearing on application either by a partner in the cases mentioned in paragraph number 1, numbers 1 to 6, or by the purchaser or assignee of a partner's interest under paragraph 2, numbers 1 and 2. Next. Number 1, on application by a partner, letter A, insanity, the partner may have been previously declared insane in a judicial proceeding. Otherwise, the fact of his being unsound mind must be duly proved. Letter B, incapacity. The incapacity must be one which affects the ability of a partner to perform his duties as a partner. For example, brain dead or comatose, it means he can perform his duties to the partnership. Letter C, misconduct and persistent breach of partnership agreement. Like incapacity, conduct prejudicial to the carrying on the business and persistent breach of the partnership agreement are grounds for judicial dissolution. If ever one partner is acting of misconduct and the other partner is asking him to leave but he doesn't want to leave, the court can intervene. Letter D, business can be carried on only at a loss. Main purpose of the partnership is to generate profit. It may be dissolved by decree of court when it becomes apparent that the business is unprofitable with no reasonable prospects of success. Lastly, other circumstances about the business, fraud in the management of the business, refusal without justifiable cause to render accounting of partnership affairs. Number 2, on application by a purchaser of a partner's interest. After the termination of the specified term or particular undertaking, and at any time if the partnership was a partnership at will when the interest was assigned or when the charging order was issued, uh, there are two examples. Example number 1, under Article 1813, A and A, B, and C form a partnership to continue for a term of 5 years. On the third year, C sold his entire interest to D. Such conveyance does not dissolve the partnership, and D does not become a partner, his only right being to receive the profits to which C would otherwise be entitled. Hence, D cannot ask for judicial dissolution of the partnership. However, if after the fifth year the partnership is continued, D is entitled to ask for judicial dissolution. The partnership, as continued, may or may not be a partnership at will. Example number 2, suppose now of the fifth year the partnership was continued by the partners without any express agreement, becoming a partnership at will. If C's interest was purchased by D or a charging order was issued by a court against C in favor of D, is judgment creditor as provided in Article 1814 when the partnership was already a partnership at will, D at any time may ask for judicial dissolution. And take note that the rule in Article 1831 applies if in continuing the business a partnership at will is created or the partnership is a partnership at will from the beginning. Next. Article 1832, except so far as may be necessary to wind up partnership affairs or to complete transactions begun but not then finished. Dissolution terminates all authority of any partner to act for the partnership. Uh, Number 1, letter A, with respect to the partners. When the dissolution is not by the act, insolvency, or death of a partner. Letter B, with respect to persons not partners as declared in Article 1834. When the dissolution is such act, insolvency, or death of a partner in cases where Article 1833 so requires. Next. Next. Effects of dissolution on authority. Number 1, general rule. Unless otherwise stipulated, every partner considered the agent of the partnership with authority as well as the other partners with respect to the transaction of its business. Upon dissolution, the partnership ceases to be a going concern and the partner's power of representation is confined only to acts incident to winding up or completing transactions begun but not then finished. And only the contracts entered into by the partners are considered included in the dissolution authority. The foregoing are the qualifications set forth in Articles 1833 and 1834 in relation to Article.
Ulitin na lang itong slide.